Good evening, everyone. Today we have with us former Madhya Pradesh High Court Justice Rohit Arya. Justice Arya was elevated as judge of High Court in 2013 and was made a permanent judge in 2015. Justice Arya retired this year in April 2024 and now has joined Bharatiya Janata Party. Thank you, sir, for joining Bar and Bench today with us. What prompted you to join Bharatiya Janata Party? Was it always a part of the plan?
Well, I had no plans, as a matter of fact, to join any particular party. But since after demitting the office, I want to continue in public life. And as I always found that my philosophy about public good and public causes are in conformity with the ideals and policies of the BJP. So I thought this is a party which may help facilitate espousing the cause of public or poor in public domain and help ensuring their socio-economic development in larger perspective for betterment of society and the country as such.
Don't you think like judges joining politics post-retirement blurs the line of separation between the judiciary and the executive?
A very good question. See, what happens that every individual has an identity when he is born, but he is given name as son of so and so. That tag is there because of he is your natural father or a foster father or what we call it. You get a name identification that you're so and so son, so and so's daughter. There should be respect for the chair for all times to come, as long as you are sitting on that chair. So once you become a judge, you forget that you are a lawyer. Then you are committed to justice, a substantive justice to the parties before you on the touchstone or anvil of the Constitution. These are the commitment for sitting over the seat of justice. And this continues till you demit the office. And once you demit the office, you are again back a citizen, which you were at the time you joined the assignment as a judge. So there is no link between a judge joining politics, because judge is not joining the politics. It's a person who was a judge after retirement has joined the politics. So there are difference. Don't mix up an individual with his position as a judge, because his position as judge has nothing to do with his subsequent life, which he's supposed to enjoy his own wishes and wills. We can, after demitting office, we are primarily a citizen, and as citizen, we have right to air our view, our perceptions, our concern, and our commitment. So there's nothing wrong if a person after demitting office either joins policy, somebody joins the college, somebody joins the what you call sport activities, somebody depending upon your interest, your concern, and your convictions.
Do you think that collegium system is the best way to appoint the judges?
100%. 100%.
The Supreme Court Collegium has been at loggerheads with the central government over its failure to process judicial appointments in a timely manner. We have seen Justice S.K. Kaul also talk about it.
I'm not supposed to speak on this issue because that is not in my domain. I can only say that on principle, it's definitely an excellent procedure and nobody should have any objections to it. The procedural issues between the Supreme Court and the central government, I have nothing to say on that. I can only appreciate the system which is in existence.
You are from the judicial domain. Will you advise the ruling party to process these appointments faster, given the burden on our judges?
Any person. Why only? Why only the? Why only because I've joined the politics. Even otherwise, it is expected that all appointments which are found to be proper, legal, and fit for appointments should be expedited. In general, everybody say this. It's a matter of routine things. So it is for the government to decide and government to take a decision. But it is expected that the earlier the better, because many high courts are there where less number of judges are working, people are suffering. So we should have this concern that every high court should have sufficient number of judges to ensure early and substantive justice to the litigants who are waiting for years together.
The central government and state governments are responsible for majority of the litigations before our courts, and many of cases are frivolous. So what do you think should be done to address this issue?
Very good question. See, before I proceed to answer your question, let me tell you, so far as my knowledge goes, out of 100% litigating population, for 85% such population, district court is the final court. Only 15% cases come to the high court, and only 8 to 9% cases go to Supreme Court. Now imagine, for 85% litigating population, district court is the final court. Now, we all need to address people of different sect of society. And all this, Honorable Supreme Court, Honorable High Courts, or central government, we need to address how best we can do at the district court level to ensure reduction of cases. And besides, proper infrastructure to district court judiciary, sufficient human resources, and of course, other amenities, logistics, etc. This should be our prime concern, that district judiciary should be revamped, reinforced to the best possible. Now, question arises, how to get over this menace of mounting areas of cases. If we resolve the disputes at the initial stages, those cases will not come to the court of law. The process of adjudicatory, process of justice or course of justice should be of such nature that it is not only the law, but compassion to do justice, blending it with law, shall definitely yield good results, which would give good message in society that litigation is not the solution, but mediation or understanding is a solution if you really want to lead a good life.
Like in 2022, you were talking about religious conversion for marriages in India pose a great threat. And they are serious threat to marriages recognized under personal law. So isn't it fundamental right of Indians to choose their own religion?
Well, in the context of those judgments, I have nothing to comment upon, because those are the matters of judgment which was relevant when I was a judge. But conversion, as a matter of fact, should be voluntarily and would be only permissible if a person attains that maturity. It should not be by way of compulsion or by way of any coercion. So everybody is free to practice religion of his own choice. In our constitution, there is no such prohibition. But it should be voluntarily, and it should be regulated. It should have a regulation. Regulations always brings a discipline in life. It is not either misused or it is not put to any criticism.
There are concerned that newly implemented criminal laws will cause a lot of confusion and lead to two parallel criminal justice system. What is your take on that?
Well, very good question. See, as I told in some interviews regarding the perspective of justice in our ancient India. See, in Bharat, the great nation, during Ramraj, the concept was threefold: observance of principles of natural justice, equal opportunity for different set of class of people in society, like children, women, men, old age people, downtrodden, etc. Everybody had a fair right of hearing. And third was speedy justice. This you would find in Valmiki's fire. In Sanatan era, ladies were given utmost respect and status as per the law prevailing at that during that time. Mahabharat Kal, it was also said that to eradicate Brahm or confusion and to protect the money, rather wealth, I should say, establishment of Maryada and Anushasana was done. आप समझ रही बात को? मर्यादा और अनुशासन की स्थापना थी महाभारत काल में, यह सामने आता है आपके भ्रम को और आपके धन की रक्षा की थी। और दंड जो था राजा का धर्म था, क्योंकि दंड जागता था जब प्रजा जागती थी, और दंड से प्रजा को संभाला जाता था कि अगर दंड है तो प्रजा सम्मिलित भी रहे। ये भावना थी उस जमाने में। अंग्रेज जब when English people came after 500 years of the Muslim rule, Lord Macaulay in 1835 had said, I have in a House of Commons that I have traveled India from east to west and north to south. This was in 1835. I have not found any beggar. I have not found any thief. This country has rich cultural heritage and absolutely flawless spiritualism. And the backbone for these two noble noble values of this country, that is the culture and spiritualism, is the education system, of which medium of instruction was Sanskrit. He said, if you want to rule this country, then you have to break their backbone and eradicate their education system with the substitution of English medium schools. This is how the English medium schools came to our country. Now, with the passage of time, this was something which was prevalent due to our cultural heritage and spiritualism, which was continuing or sustaining themselves despite Mughal oppressions. And then now, if some good thinking, right thinking persons have decided, let us have I'm sorry, I'm just dealing it. Then with that mindset, the Britishers ruled this country. They brought these IPC, CRPC and Evidence Act, no doubt, conforming to the concept of justice, equity and good conscience, no issues. But primarily, they enforced this act with the predetermination of mind to create a fear psychosis. If you, I don't know, do you know about it or not? The investigation conducted by the police at that time was known as Danda investigation, which has been also prevalent after even independence also. Danda means investigation with torture. So only threat perception was spread in public domain that if you do not work with indiscipline according to our wishes, then you will be meted out with severe punishments. This new 3 courts is a movement from Dand Samhita to Nyaya Samhita. Matlab, from penal code to justice code. It is quite a balancing act. And it does not do any offense to any person. Rather, it adds on to the policy of our constitution to do speedy, fair and impartial justice to public at large.
In 2021, there was this bail condition that you had imposed about tying Rakhi. And Supreme Court had noted that effectively, this is turning a molester into brother by judicial mandate. So do you ever regretted passing such an order?
When you're on a seat of justice, every day you pass some orders to the best of ability. We have taken oath when we became judge that we shall we will do our act to the best of our ability. Logic has no end. If in my perception something was right, I did it. If Honorable Supreme Court found it was not right, we accept it because it's a judicial discipline. That if some Supreme Court says no, you are not right, we with great respect accept it. There is nothing to comment upon it. And that's a law of the land. And every citizen is bound by law of land, much less a judge. And that is for a judge especially, it's a matter of judicial discipline. One should not comment upon the judgment rendered Supreme Court on the judgment of a judge by a judge who has been a judge, I should say. Now I'm no more a judge. I'm only a citizen of India. So I'm not supposed to comment. And why should I comment? I accept it. What Supreme Court said, that is the law. That's the end of the matter. We change ourselves. Because as I said, even law is a dynamic phenomenon. It keeps pace with the changing time. What was not a good law earlier is now found to be a good law. What was a law, many a times you find that Supreme Court overruling its own earlier judgments, because with the passage of time, the requirement society is different now. So we always say law is not lifeless. And law has to be contextually interpreted, meeting the requirement of time. So it's a dynamic phenomenon. It keeps changing. Perceptions keep changing. Ideas keep changing. Understanding keeps changing. And that is why we say law is full of life.
The BNSS, that is Bharatiya Nagarik Suraksha Sahinhita, it allows police custody beyond 15 days of arrest. So don't you think there is scope of misuse and ill treatment of citizens who may be falsely accused?
Actually, it is regulatory. It is not that you can do it on your own. There has to be judicial intervention. With the permission of the concerned magistrate, you can do this. You cannot do it on your own. It's like we give in the previous law, there is a provision of police remand. So for investigation purposes, police remand is given or judicial remand. So likewise, if detention of a person with the intervention of the judicial authority is not illegal detention. You challenge the order.
Whenever you have dealt with cases dealing with hurting religious sentiments, you have always observed that mutual respect, faith, and trust among all the citizens of India are basic tenets of coexistence in a welfare society governed by rule of law. Like you have joined a party clearly which has hurt the sentiment of minority by calling them infiltrators in an election speech. So aren't these like double standards at play here?
See, I always go by as a student of law. Constitution is of paramount importance to me. I go by the spirit and content of the Constitution. Article 51, sub clause, probably C, it deals with respect and brotherhood for other segment of people in different religion or caste. I stick to it. And no one, according to me, should hurt the feelings of minorities. This is the mandate of the Constitution. It is not yet my viewpoint. It is the mandate of the Constitution. And we all should respect the Constitution. No one is above the law. And the Constitution is the father of all laws in India. All laws flows from the Constitution. Therefore, Constitution is of paramount importance and significance to each one of us. We all should respect and abide by the Constitution.
There have been instances of video clips from your court proceedings going viral on social media. What are your thoughts on court hearings being live streamed and the subsequent use of these clips by the general public?
Actually, it is something, sometimes I feel it is not really good, as a matter of fact. See, live streaming is given only to ensure that people get a fair chance of witnessing proceedings of their cases. That is the idea behind giving a judicial order for ensuring streamlining of live streaming of the court proceedings. But what happens is that people pick up certain things from proceedings and give it some different facelift only to attract people. This is not good, because ultimately you bring to the people, if you really want to bring to the people the proceedings in the court, then bring before it what was the subject before the court, what are the contexts in which the questions were asked, what were the contexts in which the conversation took place. That would be more fruitful than giving all sorts of clippings. This was a judge ko gussa aaya. All these things do, catch attention of people, but you have no consequence. You are making a mockery of system. This should not happen. Well, if you're really interested to bring to the public what is happening in the court, then give them the reference and context of a case and tell them this is what was happening. That is a fair criticism or fair reporting.
There are, certain judges and their orders in which, their ideological leaning is reflected. And later, the Supreme Court has to intervene and set aside all these orders. So, aren't judges required to separate themselves from these biases in order to do justice?
100%, 100%. The judges should always insulate themselves from any premonitions or preconceived notions. They should go strictly by record with due respect to the facts and the law applicable to a given case. I always believe, I practiced that majesty of law is ultimate. No one has right to either disturb the majesty of law or do any pollution with the majesty. Nobody. Be a judge, be an advocate, be a litigator, be any person. Law should be given respect in entirety. And a judge is expected to give judgment upon due appreciation of facts with proper application of law to the given factual matrix, and conclusion should be tempered with compassion, always, of course, without sacrificing the discipline of law. That should be the approach, according to me, because I have always ensured that justice is done in such a manner that the discipline of law is not violated, discipline of judicial propriety is not compromised, but at the same time, looking to the scenario, factual scenario in hand, what compassion, what judgment may be delivered with an element of compassion to do complete justice between the parties. This should be the approach which I have practiced.
Thank you so much for joining today. I wish you all the best for your future things ahead. And thank you so much.
Thank you, Ratna. God bless you and good luck to you.
Subscribe to our YouTube channel and click the bell icon.